The fight over so-called assault weapon bans has just taken a dramatic turn. In Illinois, where lawmakers pushed through one of the most sweeping rifle and magazine restrictions in the country, the challenge is now heading back to the courtroom. And this time, the Department of Justice under the Trump administration has stepped in on the side of gun owners. That's a major pivot. For years, the federal government often defended state-level bans, arguing they were consistent with public safety. But now, the DOJ is filing briefs that say outright, these laws violate the Second Amendment. And with oral arguments scheduled in the Seventh Circuit, the outcome could shape not only the future of Illinois's ban, but the national debate over what firearms Americans can legally own. So, today, we're breaking down what this case is about, how the arguments are stacking up, and why this could be the moment the courts are forced to decide whether bans on America's most common rifles and standard magazines can survive under the Constitution. The controversy centers on Illinois' so-called Protect Illinois Communities Act, or PICA, legislation that outlawed many of the most popular rifles in America, along with magazines holding more than a set number of rounds. When the law passed, supporters called it a public safety measure in response to high-profile shootings. But for gun owners, it immediately felt like a sweeping infringement on their rights, because it targeted firearms and accessories that are in common, everyday use. Federal Judge Stephen McGlynn, reviewing the law at the district court level, issued a strong rebuke. He found that banning commonly owned rifles and standard capacity magazines directly violated the Second Amendment, especially in light of the Supreme Court's Heller 2008 and Bruen 2022 rulings. Those cases made clear the government cannot ban arms that are in common use for lawful purposes. AR-15-style rifles, owned by an estimated 20 million Americans, and standard magazines used in countless handguns and rifles, certainly fit that definition. Judge McGlynn's injunction temporarily blocked enforcement of the Illinois ban, but the state immediately appealed to the Seventh Circuit. And here's where the drama escalates. The state argued that the ban doesn't really implicate the Second Amendment at all, because, in their view, these are military-style weapons not protected by the Constitution. That's the same logic used in a 2015 case called Freedman v. Highland Park, where the Seventh Circuit upheld a local ban. The Supreme Court refused to review that case back then, but Justice Clarence Thomas warned that the lower courts were treating the Second Amendment as a second-class right. Now we're seeing déjà vu. Once again, Illinois is leaning on the argument that certain firearms are too militaristic, too dangerous, and therefore outside the Second Amendment. But that position ignores the Supreme Court's more recent Bruen decision, which set a new test. Regulations must be justified by historical tradition, not speculation about public safety. There is no historical precedent for banning commonly used firearms, none from the founding era, none from Reconstruction, and none before the modern wave of gun control. And this time, the federal government isn't staying neutral. The Trump DOJ filed an amicus brief siding with the plaintiffs, telling the Seventh Circuit that Judge McGlynn got it right. Their position is clear. The rifles and magazines Illinois banned are ordinary, lawfully possessed, and squarely protected by the Second Amendment. In fact, the DOJ went further, suggesting that accessories like suppressors also deserve constitutional protection, a striking departure from the government's traditional stance. So at this stage, the lines are drawn. Illinois is doubling down, the plaintiffs have federal backing, and the Seventh Circuit is once again in the hot seat. And what happens here could set the stage for whether the Supreme Court finally takes up the broader question of so-called assault weapon bans. At the heart of this fight are two competing visions of the Second Amendment. Illinois insists that its Protect Illinois Communities Act is constitutional because the banned rifles are military style, and therefore not protected arms. They lean on the old Friedman vs. Highland Park reasoning, and they argue that these rifles aren't necessary for self-defense, pointing out that other firearms remain available. In their view, limiting access to certain platforms doesn't destroy the right to bear arms, it just shapes it. But that's exactly what the federal government under Trump is rejecting. In their amicus brief, the DOJ argues that this logic is fundamentally at odds with the Supreme Court's most recent rulings. Heller made it clear that the Second Amendment protects arms in common use by law-abiding citizens, and Bruen doubled down by requiring courts to look for historical analogs. Illinois offered no historical examples of bans on commonly owned firearms. None. And the DOJ hammered that point home, writing that Illinois's law is precisely the type of restriction the court warned against, treating the Second Amendment as a second-class right. The DOJ's brief also dismantled Illinois' claim that these are uniquely dangerous weapons. Data shows that rifles of all types, including AR-15-style platforms, are used in only a fraction of gun crimes nationwide. FBI crime statistics consistently report that more murders are committed with knives, or even fists, than with rifles. And when it comes to home defense, sport shooting, or hunting, millions of Americans rely on these rifles safely every year. The DOJ highlighted these realities, pointing out that banning such firearms sweeps ordinary citizens into the same category as criminals, punishing lawful use in the name of speculative safety benefits. And here's what makes this pivot historic. For decades, federal agencies often lined up behind the states, defending restrictions in the name of public safety. But now, the government itself is saying the quiet part out loud, that common rifles, standard magazines, and even certain accessories are fully protected by the Constitution. That shift could echo far beyond Illinois, sending a message to other states with similar bans, like California, New York, and New Jersey. For Illinois gun owners, this case is about more than one law. It's about whether the courts will recognize that the right to bear arms doesn't mean a right limited to obscure or unpopular firearms, but extends to the most common platforms in circulation. And for the DOJ to put its weight on that side, that's a game-changer in the national debate. All eyes are now on the Seventh Circuit Court of Appeals. Oral arguments have been scheduled for September 22nd, and the panel will decide whether to affirm Judge McGlynn's ruling or overturn it. If history is any guide, the Seventh Circuit hasn't been kind to the Second Amendment. This is the same circuit that upheld Highland Park's ban nearly a decade ago, and more often than not, its rulings lean toward restricting gun rights. But this time, there are key differences. First, the legal landscape has changed since Bruen. Courts can no longer wade through restrictions simply by citing public safety. They have to point to historical analogs. That's a steep hill for Illinois to climb, because there is no tradition of banning firearms in common use. Second, the DOJ's amicus brief dramatically shifts the tone. It's not just grassroots organizations like the Second Amendment Foundation or Gun Owners of America making these arguments anymore. It's the federal government itself. That carries real weight in the courtroom. Even so, many observers believe the Seventh Circuit will still side with Illinois, setting up a direct clash with the Supreme Court. And the justices have already hinted at their frustration. When emergency appeals from Illinois first reached the court, they were denied. But Justice Clarence Thomas warned that if the Seventh Circuit allowed bans on America's most common civilian rifles to stand, the Supreme Court can and should take up the issue once a final judgment is entered. Justice Kavanaugh has made similar comments in past denials, signaling that the court is waiting for the right case at the right time. This could be that case. If the Seventh Circuit doubles down against the Second Amendment, it practically guarantees Supreme Court review. And if the justices do step in, they won't just be reviewing Illinois' law. They'll be addressing the broader question of whether any state can ban entire categories of commonly owned firearms and standard magazines. That's the kind of landmark ruling that could reshape gun rights nationwide. Meanwhile, other cases are already lining up. California's magazine ban, known as Duncan versus Bonta, is petitioning for Supreme Court review. New York and New Jersey face similar challenges. The Illinois fight is part of a larger wave, and the court may decide to tackle these issues head-on rather than watch lower courts chip away at its Bruen decision. So the stakes here aren't just about one state or one law. They're about whether the Supreme Court is ready to finally draw a constitutional red line. That banning common rifles and standard magazines is a bridge too far. At the end of the day, this Illinois case isn't just about rifles or magazines. It's about how seriously the courts are willing to take the Constitution. The state's argument boils down to this: some guns look too scary, therefore they can be banned. But the Second Amendment doesn't protect only the arms that politicians find aesthetically pleasing. It protects arms in common use by law-abiding citizens, period. Think about the logic Illinois is pushing. If popularity is what makes something dangerous, then the AR-15 should be the most protected firearm of all, not the least. It's the rifle millions of Americans choose for home defense, sport shooting, and competition. Standard 30-round magazines are the default configuration, not some exotic accessory. To ban those items is to criminalize normalcy. What's more, the state's claim that these are military-style weapons misses the point entirely. Every firearm traces some lineage to military use. The lever-action Winchester was once a battlefield rifle. So was the 1911 pistol. The idea that civilian arms must be stripped of any military characteristic would erase nearly every iconic American firearm from the shelves. That's why this case matters so much. If the courts allow Illinois to redefine what counts as protected arms, then every state with an appetite for gun control will follow suit. But if the Supreme Court steps in and reaffirms Bruen, that the right to bear arms isn't second class, and that bans on common firearms have no historical precedent, then we could see a massive reset in how these cases are handled nationwide. From where we stand, the path is clear. The Constitution doesn't bend just because certain rifles are politically unpopular. Rights don't vanish when headlines get ugly. And the question the courts have to answer is simple. Do we honor the text and history of the Second Amendment? Or do we allow states to chip away at it until nothing remains but the guns they deem acceptable? For millions of gun owners, the answer couldn't be more important. So here's where things stand. Illinois' sweeping rifle and magazine ban is now before the Seventh Circuit, with the Department of Justice itself stepping in to say these laws violate the Second Amendment. If the appellate court doubles down, this fight is almost certain to land in front of the Supreme Court. And when it does, the justices will have the chance to decide once and for all whether America's most common rifles and standard magazines are here to stay, or whether states can keep carving away at our rights. For gun owners across the country, the outcome will shape not just Illinois, but the future of firearm ownership nationwide. We'll keep tracking this case every step of the way. But now I want to hear from you. Should states have the power to ban rifles and magazines that millions of Americans already own? Or is that a line the Constitution simply doesn't allow them to cross? Let me know your thoughts in the comments. And as always, make sure you like, subscribe, and share this video so more people stay informed about what's happening in the fight for the Second Amendment. Thanks for tuning in, and remember, stay sharp.